Did you want to say anything, sir? You can if you wish.
No, look, I just want to say, I'm sorry, Don. That's it. I'm letting us show.
Welcome back to the channel, everyone, and buckle in because today's case is one of those moments in court where you can feel the judge's patience snap. What happens when someone is given a second chance on probation and then turns right around and commits the same kind of crime just months later? That's exactly what we're about to watch unfold. The defendant in this case was placed on deferred probation for organized criminal activity, a deal that kept him out of prison. But what did he do with that opportunity? According to the state, he went back to the streets, stealing cars, evading officers, and racking up more charges before the ink on his probation paperwork was even dry. The defense will argue he's been doing good and just made a mistake. The judge, though? He's about to make it crystal clear what happens when you test the court's patience. Stick around, because this case takes us from excuses to hard reality, and the ending hits like a hammer.
In summary, this motion to revoke unadjudicated probation states that on August 29th, 2024, that would be a year ago, over a year ago, that in this court, criminal district court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of engaging in organized activity. Allegation 1 states you committed the offense of unlawful use of a motor vehicle on or about January 2nd, 2025 in Harris County, Texas, which was a violation of condition 1 of your deferred or unadjudicated probation order, which states that you shall commit no offenses against the laws of this state or any other state or of the United States. Is this allegation true as it is alleged?
Yes, sir.
You can now be found guilty and sentenced to no less than 2, no more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true to this motion to revoke probation.
Yes, sir.
All right. There is no agreement, right?
No, yeah.
Okay. The defense can go first. What do you suggest we do?
Your Honor, if it's okay, I'll just call him as a witness and we'll
Sure.
try that way. Hey, Jordan.
He's already sworn in.
Yes, Your Honor, yeah. And you just pled true to the allegations. Is that correct?
Yes, sir.
Okay. And you're not trying to say you didn't do what they're alleging, correct? Okay. But while you've been on probation, besides these allegations, how do you feel that you've been doing?
I feel that I've been doing good, I know I made a mistake, and I own up to my mistake. I take full accountability. I feel like I can complete my probation and get it done with, and go by my business. I feel that I can.
Here's where things start off heavy. By pleading true to violating probation, the defendant essentially admits he broke the terms of his deal. That admission gives the judge wide authority to revoke probation and impose prison time. In this case, anywhere from 2 to 10 years. Notice the judge double-checks multiple times, making sure the defendant understands the consequences. Because once you plead true, there's no walking it back. This moment sets the stage. The defendant himself just handed the judge the legal grounds to lock him up. Question for you. If you were his lawyer, would you have advised him to plead true or take the risk of fighting it?
I did everything, but I was just, the thing I did was get your charge. I was standing, I was reporting, I was testing my lawyerly, so that's what I do.
Okay. That's what I'm getting at. You feel like you've been doing really good on probation, except for this new charge they should you back.
Yes, sir.
Okay. Are you caught up to all your fees?
Yes, I think I'm tired of a couple of months behind.
Because you said you've been in jail.
Yes, sir.
But before you went to jail, you're
Yes.
as far as community service, all the classes, everything you're supposed to be doing, you're up to date on that, do you believe?
Yes, sir.
Now, obviously, since you've been in jail, you're behind on that, but when you went to jail, you were up to date.
Yes, sir.
Okay. Everything going good on probation.
Yes, sir.
You were checking out like you're supposed to,
Yes, sir.
doing everything you're asked to do.
Yes, sir.
Okay. And as far as these new charges go, you're going to face them and take care of them when the time comes for those, correct?
Yes, sir.
But you didn't want to waste this court's time anymore. Want to be done with this, correct?
Yes,
Okay. And what are you asking the court to do in this case?
And if I can, with a chance to raise able to find myself or anything else and go to still off the medicine and get to not the medicine back.
So, and that's what I'm getting at. You're also willing, if the court wants to send you some kind of treatment program or something, well, first of all, if you decide to do that, you can't say no to it because it's his call. But you're willing to do that and willing to do whatever it takes.
Yes, sir.
Okay, and you're going to cooperate with the probation department and do whatever you're supposed to do.
Yes, sir.
That's what it is.
This incident happened on January 2nd, 2024. Yes,
Yes, sir.
it was at 4 o'clock in the morning. Yes,
Yes, sir.
at Dwelling Book Apartments there in Baytown.
Yes, sir.
You were arrested not only for the offense that you pled true to, but also for evading detention with a motor vehicle.
Yes, sir.
At the time in which the officers responded to this, you were in that Kia Optima.
And here comes the defense's first strategy, painting probation as a success story. The defendant says he's been doing good, keeping up with fees, classes, and check-ins, everything but this one slip-up. But here's the problem. Probation isn't graded on effort, it's pass or fail. Committing a new felony erases all those good check-ins. Judges hear this all the time. I was doing everything right, except for the part where I broke the law again. And most judges aren't buying it. Let me ask you guys, do you think the system should show leniency if someone mostly complies? Or does one violation cancel it all out?
Trying to move out of a parking spot without the lights on. Basically just trying to avoid being detected, correct?
Yes, sir.
When they went to stop you, the officer saw you, you made eye contact, but yet you put the car in drive and tried to reverse out of there and avoid the officers where the evading came from, correct?
Yes, sir.
But they caught you within the apartment complex, didn't they?
Yes, sir.
Because you were trapped. Yes?
Yes, sir.
But for whatever reason, Harris County chose not to charge you with the evading, but the truth is that you're arrested for that. It's actually what happened. And all this was at 4 o'clock in the morning when you weren't even supposed to be anywhere near that location. You're supposed to have been at home, abiding your curfew.
Sir.
You were placed on probation for engaging. Wasn't that also because you were involved with others about burglaries of vehicle?
Yes, sir.
So you're telling this court that even though you got arrested and charged with it here in our county, given the opportunity to get probation, that you quote unquote learned your lesson by going to a different city and committing the same offense?
Yes, sir.
So one more time, Mr. Dell, why should we put you back on probation?
Because I know I think that I made a mistake.
That's not a mistake, sir. Or explain to him why you think that's a mistake.
Feel like it was a mistake. It was a poor decision I made. I was wrong to not take full accountability, but I know I didn't know it existed.
I don't have any other questions, Chuck.
Go ahead, Jeff.
No more often this way.
Can I see the pre-sentence report?
I was looking for my copy. My nice probation officer has it handy.
Thank you. Stand by, peruse. There none. Do you have anything showing a probable cause affidavit on this new substantive offense that he's pleaded true to?
In all fairness,
Because I don't
Judge,
have anything in my file.
because I had this officer available to testify, I'm going to hand you his report. He's the main one. He was the one I was questioning.
How much was paid back on restitution, by the way, if anything? From probation, did we know?
Nothing has been credited to the probation. To the restitution. There's been a total of $704 paid. But I will amend it for it to go to restitution.
This is where the case goes from technical violation to straight up dangerous. Not only was the defendant in a stolen Kia, but he tried to evade officers inside an apartment complex at 4 a.m. That means headlights off, maneuvering to avoid detection, classic signs of someone actively committing a crime. The judge points out he wasn't even supposed to be out. Probation included a curfew. So now, instead of just one violation, we're stacking multiple: stolen vehicle, evading arrest, curfew violation, and probation breach. At this point, the mistake narrative collapses. What do you think? Is this desperation, arrogance, or just someone who thought they wouldn't get caught?
I had that officer and another officer on standby to come prove up the accusations, Chuck. But then we bring this other officer judge who details how they had to pin Mr. Dell in order to take him into custody. It also indicates the search incident to what was in his possession, although it's not alleged, it's certainly a note to.
Looking at the earlier pre-sentence report, which shows the defendant was convicted in January of 24 for burglary of vehicles, convicted on June of 24 illegal possession of a controlled substance, and convicted in June of 24 illegal possession of marijuana. And what do I ask them to that July 9th, 2019 illegal carrying of weapons case out of Ascension Parish, Louisiana?
He has three,
When? They know where he is.
I'm sorry, 2 active misdemeanor warrants and 1 felony warrant. Eric?
And in this report, it states that in that Ascension Parish, Louisiana case, that the court proceedings began in 2019, at which time the defendant was arraigned and pleaded not guilty. However, he failed to appear for court on several occasions thereafter, resulting in a bench warrant being issued in 2021, which remained active. So he's got that going on. And okay. Thank you. There's yes. Thank you. Yeah, I mean, right. I'm looking at a Baytown police report dated January 2nd, 2025. Is that right?
Yes, sir.
Which is what, which involves the matter allegation number 1, the defense pleaded treat this motion to revoke probation. Let's I observed the subject's attempting to drive off due to the positioning of Officer Peaks and my vehicle. The subject sideswiped a silver 4-door Cadillac before driving off towards the west side of the complex.
Here's a turning point. The prosecution lays out the defendant's criminal record: burglary, drug possession, marijuana, even an illegal weapons charge from Louisiana. And worse, he skipped court dates, leaving bench warrants hanging over his head. This is devastating in a revocation hearing because the judge now sees a pattern. Not just one bad night, but a history of ignoring the law and skipping accountability. The defense can argue mistake all day long, but this rap sheet makes it look like a lifestyle. Let me know in the comments, should past charges weigh this heavily, or should the judge only focus on the current probation violation?
The subject evaded about a quarter of a mile inside the complex, but was cornered near Building 2 and the exit gate. He again attempted to make a way around patrol units, but was pinned in by Officer Peak and myself. Officer Peak used his vehicle to pin the front of his vehicle, and I pinned the front wheel well area. I exited my unit, threw down on the suspect, who was moving to the front passenger seat. He began exiting the vehicle through the front passenger window, but was met there by Officer Peak, who took him to the ground. He was then handcuffed by Officer Mitchell. A backpack was removed from the subject. He was searched by myself and Officer Mitchell. I later learned that the vehicle subject was driving was a fresh stolen vehicle. I later contacted the registered owner of the Cadillac, and she stated she wants nothing to do with the vehicle. The vehicle was registered to her, but was brought to her brother-in-law, who has since sold it. Completing inventories of the subject backpack and found 3.8 grams with packaging of marijuana. I submitted for disposal, and the remaining items were submitted for safekeeping. Also, 2 pairs of shoes, 1 speaker, 2 cell phone charging cords, 1 vape, 1 Apple AirPod, black Apple iPhone with scratches all over it, 1 black Apple iPhone with a broken front and back, a screwdriver, and purple cotton sack with coins. All right. Oh, that's another reason why under the justice. The everything. And this was just another burglary. Which is what he does. Hadn't learned a lesson on my watch here. You were committing that crime how many months while on probation? Let's see. September, October, November, December, 4 months. Hold on. Anything else?
This moment seals the coffin. Officers search the defendant's backpack and find drugs, phones, tools, and even a screwdriver, items that scream burglary prep. This isn't just wrong place, wrong time. These are burglary tools paired with stolen property during an active evasion. To a judge, that's not rehabilitation, that's escalation. And did you catch the detail? Only 4 months into probation and already back to crime. Imagine being the judge who signed off on probation only to see this. Would you feel betrayed? Because that's exactly what the prosecution is leaning into here. Not just lawbreaking, but disrespect to the court's authority.
Not from the state, Judge.
What are you asking for? State and defense?
Judge, my opinion is that it would be a shame on us if we continue him on probation. Yeah, I've heard you say that same thing many times. And I take it to heart whenever you say not on my watch. And I feel the same way. We gave Mr. Dale an opportunity because his record did not show a felony conviction. It was a post PSI that gave us the detail of all the other crimes that he was accused of and the misdemeanors that he's been convicted of. But unfortunately, Mr. Dale did not get the message, did not make any serious attempt to complete probation, and it would be a shame on us if we don't send him to TDC. That's where he needs to go. My opinion is because he committed the same crime, that it'd be for a period of at least 5 years.
Our position is to continue him on probation, Your Honor. He stated that has been doing well on probation, except for this new slip up that he did. He took responsibility for. He's still got to face those charges for that as well. That's coming up after he leaves here. I assume that he's going to be heading over to Harris County. It is Harris County, right?
Yes.
I know it's Baytown, but I know part of Baytown's a chamber. So to take care of these charges, my request is keep him on probation upon resolution of whatever they do in Harris County for him. Assuming if they give him probation over there, run concurrently. and they go from there. And if not, if he gets prison out of
Now, watch the defense pivot. They acknowledge the new charges, admit the defendant still has to face Harris County, but ask the judge to keep probation alive. Their argument? If Harris County goes easy, probation continues. If Harris County gives prison, he can serve time and return to probation later. It's creative, but think about the message. Essentially, keep probation open as a backup plan. To most judges, that sounds less like rehabilitation and more like gaming the system. Do you think this plea had any shot of working? Or was the defense just playing for sympathy at this point?
Harris County, then when he gets off prison, back on probation and serve out the rest of this term.
Did you want to say anything, sir? You can if you wish.
No, I just want to say, I'm sorry, Don. That's it. I'm letting us show.
Anything else? If not, then I'm going to make the following findings, sir, that there is sufficient evidence supporting this motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 1 has been proven true in this hearing, and the court finds that your deferred or unadjudicated probation is hereby revoked. In this case, earlier, you pleaded guilty voluntarily to the 3rd-degree felony of engaging in organized criminal activity. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this 3rd-degree felony of engaging in organized criminal activity. I now find you guilty beyond a reasonable doubt of the offense, and I am hereby sentencing you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. It's the same kind of wrongdoing within just a few months of us putting you on probation. Also, the judgment shall reflect restitution is owed in the amount of $3,883. Anything else on this? That is all, sir. You have a right to appeal this matter. This was not an agreement.
Right.
So you have a right to appeal this revocation. Discuss that with your attorney.
And there it is, probation revoked. The judge points to the defendant's quick return to crime, his long criminal record, and the fact that he showed no signs of change. The sentence, 6 years in the Texas Department of Criminal Justice, plus restitution of nearly $4,000. What's striking here is how quickly this all unraveled. Within 4 months of probation, the defendant went from walking free to 6 years behind bars. The lesson? Judges don't take kindly to second chances squandered. What do you think? Was 6 years fair or too harsh? Let us know in the comments. And if you found this breakdown as shocking as we did, hit that like button, share this video with friends, and don't forget to subscribe for more jaw-dropping courtroom moments. Until next time, stay sharp, stay informed.